Good morning, this is your Kelso Report for Tuesday, September 4th, and I'm your host, Clark Kelso. Well, rather amazingly, litigation over Marilyn Monroe's death continues 50 years later. At issue in Green Archives versus Marilyn Monroe is whether Green Archives inherited a right of publicity, which was created and deemed posthumous by the states of California and Indiana, decades after her death, through a residual clause in her last will and testament. The will was subject to probate in the state of New York, which does not recognize a posthumous right of publicity. The issue of Green Archives rights turned on whether Monroe was domiciled in California or New York at the time of her death. In Green Archives, the Ninth Circuit concluded that because Monroe's executors consistently represented during the probate proceedings and elsewhere that she was domiciled in New York at her death in order to avoid payment of California estate taxes, among other things, Green Archives was judicially stopped from asserting California's posthumous right of publicity. It would appear that Marilyn is clearly now in the public domain. Next, an intellectual property case involving copyright. One of the characteristic features of Silicon Valley and the explosion in e-commerce has been the talented engineers and employees often will develop a valuable program at one company and then be lured away to the next great startup. This happens from CEOs down to line programmers. Now, as we have talked about recently, California law facilitates and encourages this employee movement by refusing to enforce restrictive non-compete covenants, employment covenants that in other states would restrict such rapid employee movement and competition. So employers in California look to other legal doctrines to prevent prize employees from taking their talent elsewhere. One such body of law is, of course, the law of intellectual property. An employee may be able to go elsewhere to work, but he or she cannot take with them patents and copyrights owned by the former employer. Well, that was the question presented to the Ninth Circuit in U.S. Auto Parts Network versus Parts Geek, where the programmer who built the e-commerce system for the plaintiff decided to spin off with some fellow employees into a new company, the defendant. When the defendant's business started taking off with strong sales, the plaintiff sued for copyright infringement, alleging that the e-commerce system used by the defendant was an infringing copy of the plaintiff's system. The district court ruled against the plaintiff, granting summary judgment because it concluded the plaintiff did not own the allegedly infringed copyright. The Ninth Circuit reversed, because it found genuine issues of material fact as to whether the plaintiff owned the copyright in all or a part of the software. In particular, the district court failed properly to apply the work-for-hire doctrine under the Copyright Act. Ownership of a copyright vests initially in the author of the work, which generally means the creator of the work, the programmer. But there is an important exception for works made for hire, where the employer for whom the work was prepared is considered the author, unless the parties have agreed otherwise by signed writing. The evidence strongly suggested that the programmer who authored the e-commerce system worked for the plaintiff at the time the programmer made certain significant additions to the system, additions which constituted derivative works under the copyright law and pursuant to the work-for-hire doctrine, belonged to the plaintiff. The case was remanded for further consideration by the district court. Next, we have a case involving trees. The defendants shared a property line with the plaintiffs, and the defendants cut down a tree that was growing directly on the property line without the plaintiff's consent, and the plaintiff sued. The trial court awarded a total of over $100,000 in damages to the plaintiffs based on Section 3346 of the California Civil Code, which permits a trial court to award double the amount of assessed damages in cases involving injury to trees. The defendants appealed, contending that the trial court improperly failed to reduce damages to account for the fact that only a portion of the tree's trunk was located on the plaintiff's side of the property line. The second district disagreed with the defendant's argument and affirmed the judgment. According to the second district, the trial court could and did appropriately consider the tree's unique characteristics and the great personal value it had to plaintiffs. In particular, the tree's unusual size and form, basically a few feet from the base of the trunk, it split into two separate trunks, made it very unusual for a line tree. It functioned more like two trees growing on the separate properties. The tree's attributes, such as its broad canopy, provided significant benefits to the plaintiff's property, and the plaintiffs placed great personal value on it. The trial court correctly recognized that it could account for these factors when determining damages. Finding no abuse of discretion, the appellate court affirmed the judgment. So before you go cutting down trees, make sure you know which trees are on your property, and make sure you know what legal rights your neighbors may have. We turn from trees to domestic partnerships. We have a case here involving the procedures that two individuals must follow to become domestic partners under California law. Procedures which are materially different from how two individuals become married. One, James Burnham and Kathleen Honeyman, wanted to become domestic partners. On a Saturday morning, they completed a notarized declaration of domestic partnership. Later that afternoon, Burnham died. The following Monday, Honeyman presented the declaration to the office of the Secretary of State, and the clerk filed it. Thereafter, Honeyman applied for Burnham's state pension survivor benefits. That was challenged by Burnham's heirs. Now, the legislature by statute has enumerated the requirements for establishing a domestic partnership. The statute states that, quote, a domestic partnership shall be established in California when both persons file a declaration of domestic partnership with the Secretary of State, and at the time of filing, both persons are capable of consenting to the domestic partnership, close quote. Giving this provision a plain meaning interpretation, the third district held in Burnham v. CalPERS that presenting a declaration of domestic partnership for filing with the Secretary of State is a necessary prerequisite for a valid domestic partnership. And at the time of presentation, both individuals must be capable of consenting. Since Burnham was deceased when Honeyman presented the declaration of domestic partnership, Honeyman and Burnham never became domestic partners, and Honeyman was therefore not entitled to Burnham's state pension survivor benefits. As the court noted, up until the moment of filing, where both persons are capable of consenting at the time of filing, either party can walk away from a signed declaration. It is not the declaration, according to the statute, but the filing that creates the legal relationship. We close today with a classic tort case involving two neighbors who really didn't get along, leading ultimately to a six-figure judgment in the case of Plotnick versus My House. One of the neighbors built a 6-foot-high fence between their properties that led to a complaint to the community association and a settlement agreement between the neighbors, where the fence was taken down and replaced by a 3-foot-high fence. Well, after that, there were repeated instances where the defendants engaged in behavior clearly designed to intimidate and humiliate the plaintiffs. Things came to a head one day when it appeared to the plaintiffs that one of the defendants had struck the plaintiff's 15-pound miniature pincer with a baseball bat, resulting in a broken back leg that cost several $1,000s to repair. When the plaintiffs then confronted the defendants about the incident, members of the defendants' families gathered around and started calling the plaintiffs names and threatening to kill the dog. The confrontation lasted about 10 minutes, and resulted in the plaintiff suffering severe emotional distress. The plaintiff sued for assault, trespass to chattels, intentional infliction of emotional distress, and negligence. The jury found in plaintiff's favor on pretty much everything. The Fourth District partly affirmed and partly reversed. First, it held there was no assault because of the rule that words, even insulting and degrading words, are insufficient by themselves to constitute an assault. And there was insufficient evidence that plaintiffs were in imminent apprehension of a harmful or offensive contact. There was a confrontation, but no contact. Second, the court agreed that there was a trespass to chattel arising out of the baseball bat attack on the dog. Interestingly here, the court held that the plaintiffs could recover damages, not only for the resulting economic loss from the veterinarian bill, but damages for their own emotional distress. The court recognized that as a general matter, under the law of negligence, damage to a household pet results only in an award of economic loss. But the court reasoned that the rule is different when the defendant has intentionally harmed a household pet. In cases of intentional harm to chattels, the plaintiff may recover consequential emotional distress. Third, the court held that although there was no assault, the evidence supported a finding of intentional infliction of emotional distress. Words may not be enough for assault, but in an appropriate case, when combined with clearly intimidating behavior, the defendant's behavior may be sufficiently outrageous to support the IIED cause of action. Now, this has been an expensive feud for the defendants. The court affirmed total damages in the amount of $160,000 against the defendants, plus $94,000 in attorney fees. My personal hope here is that these parties no longer live next to each other, because otherwise we may have our own modern-day Hatfield and McCoy dispute in Southern California. And that's it for today's Kelso Report. Have a great day in the law.